Justice Peter Hamill sits as a judge of the New South Wales Supreme Court and the Court of Criminal Appeal. In this episode, he speaks with a refreshing and powerful candour about the important topic of mental health issues for both judges and barristers. We hope you enjoy the conversation.
Welcome to Elephant in the Courtroom, a show in which we like to look behind the routine appearance of the law. My name's Nick Hogan, and this is of us, Ahmad. We are both barristers practising at the New South Wales Bar in Sydney. We want to share a few hidden gems going on in courtrooms and some first-hand insights from those who play a role in it. We cover topical things, experiences, stuff you might find interesting, and we'll try hard at all times not to undermine your confidence in the rule of law. Vasi, how has the rule of law been treating you lately, mate?
Good morning, Nick. Well, I haven't been arrested, so I'm participating in other ways.
Yeah, because you've been too busy otherwise,
yeah,
haven't
that's
you?
right.
Back-to-back court trials and the
no
like.
time for anything like that. So I'm happy we are on the tail end of a very, very long law term. Too long for me. Back-to-back family law trials can really erode one's personal inner well-being and anxiety can really get you going. So I'm happy now that I've got a bit
Even
of
a rock
break.
like yourself, Vasi, someone who's able to withstand all manner of sort of challenges and battery going on in the courtroom.
I read somewhere that it was commonplace for barristers not to be blub. I don't know what that means, but apparently it means not to talk too much about. Well, no, it was a paper. Honourable Michael Kirby and Alan Neville Rand once said, Balmain boys don't cry, barristers don't blub, and this is a word you can help me with, lawyers aren't lachrymose.
I think we better ask our guest about that word.
Do you know what that
today,
word is?
Because
Every word...
that you've actually got me there.
Have I?
Yeah. But I'm not unhappy about that because I think we can. It's actually can ask our guest today because it actually that what you've said there is a nice lead into where we're going today on the show. Yeah. We've got a fantastic.
I'm always good at leading it, aren't
Oh
I?
no, you're a journalist, even if it's inadvertent. So we are going to talk about stress in the practice of law today, the effects, the risks of that, what can be done about it potentially.
Yes.
It's an ongoing theme. It's a big theme at the bar. It ties in with and at the bench, and we have someone who, from an anecdotal perspective at least, and as a human, I think, is excellently qualified to speak about it. He is none other than Justice Peter Hamill of the New South Wales Supreme Court. Justice Hamill will speak today on these topics as now a sitting judge, but as he was as a criminal barrister leading criminal silk at the New South Wales Bar for a number of years and his experiences.
We've done pretty well this year. This is our 5th episode, and to have a sitting judge come onto the show is a tremendous honour for us. But you know that a couple of friends of the show this week, Nick, have launched some books. Last episode we spoke in detail about the humanity of law, selected essays of James Allsop, edited by Ruth Higgins of Senior Counsel and Kevin Connor of Senior Counsel. On the last occasion we didn't have a hard copy. I thought I'd bring in my autographed copy.
It's a beauty. I didn't realise it was going to be hardbound.
Papers like these need to be hardbound, you'd think, to carry the gravitas of the...
Oh, absolutely.
There's another friend of the show, though, did launch his second book. You'll recall, our listeners will recall, when we interviewed the Honourable Stephen Walmsley, he launched a book called Ian Barker QC, wait for it, Prince of Barristers.
I love that term, Prince
of Barristers. It's a bit Brian Lara-esque, isn't it?
Oh, yeah. Well, it just bespeaks a bit of beautiful sort of flourish and, wondrous sort of advocacy, doesn't it?
And I went to the book launch and...
We try to avoid cricketing analogies on the show.
No,
do we encourage them?
I just don't think we can avoid them. We just, as you've always told me, you do you. So on Wednesday, the 20th of November, we had a book launch. Now, I felt perhaps compelled to go, in a busy time because I was worried that maybe, just maybe, there would be not enough people to support the launch of a book at that time. I couldn't find a seat, Nick.
Yeah, it was at the Bar Association common room.
At the Bar Association common room, and I sat at the back, and I couldn't buy a copy.
Who spoke? Who introduced?
Virginia Bell.
Yeah.
Of the High Court.
Indeed.
She gave the most rollicking insight into Ian Barker's life as an advocate, his personal life and his life as an advocate. Obviously, there was some comments by both Dominic Toomey, Senior Counsel, who's Senior Vice President, the Bar Association. Ruth Higgins spoke briefly, and then his Honour former Judge Walmsley spoke. And you might recall in that interview, he's a man of few words.
Yeah,
but
well chosen, well
chosen words, and
absolutely.
So there was nothing. It was felt beautiful to see him speak in a similar manner, in a kind of laconic and understated way, but he just delivered his tribute in a beautiful way, and it was a fantastic function.
Ian Barker was a legend, wasn't he? Indeed, among a group of legends, including the late Tom Hughes KC, yes, who passed this week. He was a giant of the bar. James Allsop spoke about him in the 1980s when he came to the bar, and how Tom Hughes was really flying at that stage. He reached the age of 101,
right?
If you believe it.
Right.
A great innings, sorry for another cricketing analogy, but and was just another legend of the bar. So Ian Barker, I think, certainly fell into or falls into that category, Nick, as well.
I should be remiss not to mention that I also attended the Humanity of the Laws book launch, and there His Honour Chief Justice Stephen Gageler spoke in depth about the book, and he said that there are those that think about the law, and then he said there are those that think about thinking about the law, and then he says there are those that think about thinking about the law, and there's no one better at that than the Honourable James Allsop. So
one of the themes I liked that we spoke about with James Allsop was this importance of right brain thinking, and how that's a means by which, or a style of thinking that brings a judge's and a barrister's humanity to the law, but the judge has the power to sort of see that into effect. Whereas, as you were saying, barristers are more the miners, the data miners, trying to get all the information that suits their argument, but the judge ultimately brings that side, particularly in areas like sentencing and areas where
things that involve that judgment,
that intuition, that less defined rule-based style of thinking, and that's something that we can explore with His Honour today.
Just whilst we're waiting for our illustrious guest to arrive, do you think that that right hemispheric aptitude or part of your advocacy develops more on an appellate level, because that's where you're really starting to question foundational principles for errors of law? Or do you think that's why barristers do get stuck in the left hemisphere, because if they're in trials or in lower courts, just getting the facts and the law fit neatly into a puzzle?
No, not really, because I think even at trial level, once you get to the point, and I don't say that I'm even there yet, but I'd like to think I'm starting to get there after you've probably been at the bar a decade or so. Some get there quicker. Is that you, rather than simply thinking about this idea of data mining and facts and trying to establish certain facts and what have you, I mean, as His Honour did say, facts decide cases, and that's the law oozes from the facts, I think was the way he put it. This is James Allsop. I think it's important that when one's formulating and deciding upon arguments, that you need to find an argument that is attractive at a level beyond simply it fitting with your factual case.
Right.
And that's where I think that sort of right brain thinking comes in, because an attractive argument, and I think this is something His Honour James Allsop said in various papers as well, that there's something intrinsically attractive about an argument that appeals to something deeper. Notions, if you want to call it fair play, community standards and all that sort of stuff. And we don't all have cases where there's something bigger going on, but oftentimes if you're dealing, particularly in common law, if you're dealing with a human, but even in a commercial case where there might be some sharp practice or family law work that you're doing, you're trying to appeal to a judge's sense of that. So you might as well find in the arguments that you're putting the ones that best promote those things.
I think that's a really profound perspective, if I can say, Nick. But I also, I
think it's a bit idealistic.
The counter to that for me is only that at trial there's so much going on, right? There's so much evidence, there's facts, there's all these little bits of detail that find their way into the hearing, and you've got distractions that people don't have the clarity of mind necessarily to allow the left and right to talk to each other. And I suppose what the hope is that you leave that for the judge to determine as and when he or her honour resolve it.
But if you're putting an argument, the ones that sell seem to be the ones that just feel right, and that's all it is.
That's right. Okay. So all well at your end? You're ready for the
end
of the year?
Yeah, we're ready for the end of the year. Okay. Similarly, very busy time, and very much looking forward to our guest today. Our guest today was called to the New South Wales Bar in 1989. He was appointed senior counsel in 2004 and then practiced as one of the leading counsel at the criminal law bar until he was appointed to the New South Wales Supreme Court in 2014, where he now sits as a first instance judge and a judge of the Court of Criminal Appeal. He is none other than Justice Peter Hamill. Welcome, Judge, to the show.
Thank you. Thanks, Nick.
It's great to have you on.
Thank you.
We've obviously done there's things we've available on the public sphere about you, obviously, which we've read,
and the private sphere,
But I read your swearing-in speech with much enjoyment and interest. Lots of colour in there, and lots of interesting insights into you as a person, somewhat. And Philip Bolton said he seems to, I think, a great colleague and probably friend of yours. He said that your Irish heritage explains much about you. And firstly, at probably a surface level, it may explain your love of the Boston Red Sox. That's quite well known. Why is it, I know Boston's an Irish Catholic town, but why is it that someone who hails from Sydney, Janelli, I think it's where would love the Boston Red Sox so much?
Well, it started with a love more of the game, which sort of stemmed out of seeing some of the first World Series that were shown on Australian TV, which involved the Toronto Blue Jays. And then the Ken Burns 9-part documentary.
Ken Burns, what a legend.
And indeed. And then I was in love with the game and the Red Sox history of coming so close but losing and letting you down every time just appealed.
There was thought to be a curse, wasn't there? Because the Yankees bought Babe Ruth in 1920, from memory. And they didn't win until 2004, is that right?
2004, yes.
Do you know where you were? Were you following the game at that stage?
Yeah. I was in a pub in Sydney watching Game 4 of them, but the more interesting and historically significant series was the one against the Yankees, which was the American League Championship, where the Red Sox went down 3-0 and came back to win. No, that's 2004.
That season, that was the big win, wasn't it?
Yeah, so they came, having lost Game 7 the year before to the Yankees, they came back from 3 down, which no team has ever done and ever probably will do again.
Can I do a pop culture reference in the middle of this? Yeah. Have you seen Good Will Hunting?
I have.
And you know what my favourite scene of Good Will Hunting is? And I want to ask you this quick, and I'm just going to play it to you because it's just worth it.
And you don't regret meeting your wife? Why? Because of the pain I feel now? Oh, I got regrets, Will, but I don't regret a single day I spent with her.
You missed Game 6.
Yeah. This is the one.
So
Where
when
were you?
you know
I want to ask you, where would
she
you?
was the one
What would
for
you
you.
have done?
October 21st, 1975. Jesus Christ, you know the fucking day? Oh, yeah. Because it was Game 6 of the World Series. Biggest game in Red Sox history? Yeah, sure. My friends and I had slept out on the sidewalk all night to get tickets.
You got tickets?
Day of the game, we're sitting in a bar waiting for the game to start, and in walks this girl. It was an amazing game, though. Bottom of the 8th, Carbo tied it up. It was 6-6. It went to 12. Bottom of the 12th, in stepped Carlton Fisk. Old Pudge. Steps up to the plate, he's got that weird stand.
Yeah.
And then, he clocks it, High ball on the left field line. 35,000 people on their feet, yelling at the ball. But that's not because Fisk, he's waving at the ball like a madman. He's going, get over! Get over! Get over! And then it hits the foul pole. Oh, he goes apeshit, and 35,000 fans, they charge the field,
Yeah, and he's fucking
Oh,
blowing
no, he's
people
like,
out.
get away!
I can't fucking believe you had tickets to that fucking game.
Yeah.
Did you rush the field?
No, I didn't rush the fucking field. I wasn't there. What? No, I was in a bar having a drink with my future wife.
You missed Pudge Fisk's home run?
Oh, yeah.
To have a fucking drink with some lady you never met?
Yeah, but you should have seen her. She was a stunner.
I don't care if
Oh,
fucking...
no, she lit up the room.
I don't care if Helen of Troy walks into the room.
Helena
That's game
Troy.
6. Oh, my God.
So where's the great scene?
Alan of Troy. So what I want to know
The
is,
question is,
you were at a pub. What would you have done if Game 6, you could have seen Game 6 in 1975 or 2004?
Well, I guess.
How much do you love the Red Sox?
Well, yeah. Well, I think I would have gone to see About a Girl,
Yeah.
as Robin Williams subsequently
That's-
described it. But
So that's
but a
why-
difficult decision for sure.
yeah, oh, definitely.
And I should note they lost Game 7.
They did.
following
They
that.
lost Game 7. I was
So
looking
the
into that.
decision was vindicated.
So we were that particular home run with Fisk sort of pushing it fair is memorised at Fenway, and my son and I went there last year and was standing up, and there's this great sort of plaque of him doing that. It's around, well, not the most famous.
It's shivers
Home run
down your
Red Sox.
spine
But
stuff,
you've
though,
got
isn't
to,
it? I mean, it's
but
certainly.
you got to go see About a Girl over that.
Yeah.
But there's also, I think, something about, I mean, the obvious underdogs, and do you think that keys into something about you that and underdogs? Is there anything where you have a sympathy towards underdogs?
Well, I've certainly been accused of that. It
Well,
may
so-
explain
wasn't an accusation.
it may explain my professional career. It also, there's also something about the tragicomedy of it. It's beyond. There's a bit of underdogs, but the Red Sox are a very big team with a lot of money. But it's my football team is Collingwood, and they have done similar things. They've lost more grand finals than any other team, and they've lost them close, and they've lost them controversially.
Yeah.
And I've always loved that about them.
This is why you might also have that slight empathetic response to the Pakistan cricket team whenever I talk to you about the cricket.
Well, yeah, I've loved Pakistan and Indian cricket since I was a little boy.
There's also a strong. This is something that I think you mentioned in your swearing-in speech about how your mother gave you a very strong sense of justice and fair play. Was that something that got you into the law? What motivated you to become a lawyer in the first instance?
Again, I think there's a fair bit of that, and that developed over years. But I think initially it was the drama and theatre of it, and watching Rumpole of the Bailey as a young man or boy again, and loving that and thinking, and the fact that he was always standing up for the little guy and being bullied by judges and fighting back against.
So was it always law then, or was it some greater meaning or some kind of injustice?
He was also an underdog.
It was actually always law.
He was also a great underdog, wasn't he? And
He
that
did.
lovable underdog. I love that about him.
He liked the red plonk as well.
He did. No, he did. That was that was made. It was part of his sort of comic makeup. But I mean, it may be something we can get to at a more general level. That maybe barristers, have coping mechanisms. One of them. Did you always want to be a criminal lawyer? Is that a Rumpole thing as well, or did you think to yourself, if I'm going to do this, I'll do criminal law?
Yeah, no, it was like from quite a young age, I wanted to be a criminal defence lawyer. That was what I always wanted to be for as long as I can really remember having any ambition in the work. And that I mean, it sort of stemmed from Rumpole. I'm sure my mother's fair play thing would have played into that, but I kind of like the theatre of it.
Yeah. Did you have a performance instinct or a zest when you were schooling and through university at all? Did you like performing in any?
I did debating, and
Right.
indeed, at about those times, I remember the history master who judged a debate saying I had a style suited to the bar.
Yeah.
And because my father spent a lot of time in bars, I thought that's what he was talking about. But as it turned out, it was being a barrister, and that again fed into it. And that was.
It sometimes can take someone to say something like that to trigger in you at a younger age. Well, that gives me a sense of what I'm about and where I should go. Yeah. There was a shorter version of the swearing-in speech in the Bar News, but I think it was pretty faithful to the speech itself, where I'm talking about now the transition from you were a solicitor for not long, and then you decided to go, I assume you decided to go to the bar, but you were first an associate to the Honorary Justice, then High Court Justice Mary
How did
Gordon.
that happen? How did moving from... I think,
Sorry, can I just say, it said, after a short stint working in a small firm of solicitors at Manly, His Honour served as an associate to Honourable Justice Mary. So... how did that occur?
I mean, like many people in those days, I didn't really know about the sort of career path that went through working with a judge. And it happened that I'd been lucky enough to study with someone who of us knows very well, Kevin Connor. And we'd done a great deal of study together. And he, because he's kind of brilliant, got a job with Mary. And he was working with her. She'd started a system where there was job sharing between the associate and the tip staff. And his colleague, Margot, I think her name was Margot Stubbs, perhaps, was wanting to go and study in America. She was leaving early. She said, get your friend Peter to apply, Kevin's too proper to do that. Eventually Mary found out. She said, make him ring me. I rang her.
Oh, wow.
And I was quite unhappy not desperately unhappy, but I wasn't very happy at the law firm. It was all about money and not much about service. And so I rang Mary, and 10 minutes later she was offering me a job, which was pretty bizarre.
I suppose one of the other interesting things of that story would be if you could tell me in another episode what it was like to go to university with Kevin Connor.
Well, I never did. I pride myself on the fact that I never did go to university. I did what was then called the Solicitors and Barristers Admission Board course. The highest my academic achievement is a diploma. And Kevin was at the time acquiring a first-class honours degree in medicine at New South Wales University. We met and formed a study group because we were both based in Cogra or thereabouts. What was it like? I don't know. Challenging in the sense that you would have a study group with him one night. 48 hours later, he will have done 24 hours of work at the psych hospital as part of his medical degree.
Wow.
Learnt this and come back and known the whole of the equity textbook. It was hard to keep up.
Frustrating. Mary Gordon, Casey, she was and has been one of your heroes, I think, if I could call her that.
You can call her that.
I think she's been a hero to many, rather, and what she stood for, what she obviously famously did in Mabo and other judgments, among many other enormous achievements in the law. You said that she was loved. That's how you described her. I think not, again, only you, but others, but that she would consider that a bit mushy to say that. Why would she consider that mushy? What do you mean, and why would that be?
Mary, whilst she's sort of like one of the softest people on the inside that I've probably met, one of the most compassionate, has a fairly, I hate to say harsh exterior, but to put that in context, 2 hours after I made that speech, I went to lunch with my family and some friends, and Mary was one of them. And I walked in last, and she grabbed me, took me aside and said words to the effect of, Are you allowed to say that now? I think you are. I'm not sure. I'm not up to date on the federal court.
Well, it depends on which camp you're in.
Well, anyway, I won't put in inverted commas.
No, we won't ask you to
I
sign
think we're
something
back.
like
I think
that.
you're allowed to, but others aren't.
Yeah. Anyway, she
Becoming an
said something like, "I've spent 20 years acquiring my reputation as a heartless bitch, and you spoil it in 5 minutes."
Yeah. Wow. There's, so, and you, when you took your appointment and you were making your decision, again, this is something I think that you spoke about. You spoke to Mary Gordon about it, and she said, well, at least it's honourable,
She did say that.
or you could keep having fun.
Or you could keep having fun.
And was that the sort of the tension about the maybe not having as much fun when you, is that something that went through your mind to moving from the bar to being a judge?
I'd really not contemplated being a judge. That was not, I mean, probably everybody says this, but I genuinely can say I had not contemplated it when it was first canvassed with me a couple of years earlier, and I said I'm not ready. I actually had a pretty severe anxiety response before I told the then Chief Justice I wasn't ready. There were a number of reasons for that, but people had talked about it, but I hadn't taken it seriously. I thought, why would they do that? That is the government. Why would they appoint me? And so, yeah, when it was raised as a serious proposition, I became incredibly stressed for a couple of days, which really told me what I needed to know, which is I was not ready. But it then made me think that the job I was doing was so high maintenance. Yes, it was fun, but it was always fun after the event. It was never fun while the event was happening. I was a very, very stressed out barrister. And so I thought that I hadn't reached the point where I didn't want to do it anymore, but I thought I might reach it and it might not come back. So the second time it came, I also had a pinky promise with Dina Yahya to accept it the next time, and she would apply for the district court.
Judge, can I respectfully challenge you on that?
You
Can I respectfully
you can do it
Can I
with or
respectfully
without
test
respect.
to test that proposition that you never thought you'd be a judge? Is that's what you said, right? I mean, yeah. But did you start the bar thinking that's where you could end, you wanted to end up? I mean, I can see it moving as you get through the bar, but when you're starting at the bar with all of the ambition for service, like you've sort of said, wouldn't being at the command of the outcome be really something that would impress upon you?
It was never part of my ambition until it was kind of, I'm trying not to say offered to me because I think I'm speaking indiscreetly when I say that, but it was offered to me.
When it was
canvassed and it was real, I had not contemplated it as a realistic thing, and I'd certainly never dreamed of doing it. And even when I took it, I wasn't sure if it's what I wanted. I actually sought counselling for the transition, but it turned out the transition was absolutely fine, and I loved it almost immediately, partially because my stress levels plummeted by about 80 or 90% was my calculation almost immediately. Like from day one, I felt less stressed, less like vomiting in the morning.
Yeah, you did have a cycling accident at the time, didn't you? Which you was compared to, I think, compared in that speech to the white elephant turning up at Dubbo Zoo and running headlong into a tree, head first into a tree, and you had actually a reasonably serious at that very time of your appointment.
So between the time of the appointment being accepted and going through cabinet and its announcement, or certainly the swearing in, I came off my cycle badly and snapped my humeral head, I think the bone is, and
for the personal injury lawyer.
Which was kind of convenient because it meant I could then dump all of my outstanding cases except for one, which my solicitor insisted that I finish, but otherwise I had a nice break. Paid for by a nice insurance company.
Another
and it was white rhino.
White rhino, a white rhino.
I'd rather be extinct than live in Dubbo was the punchline.
Another, I guess, hero or someone you've spoken about a lot, and I recall speaking with you about this at a social function. It may well have been Awais' wedding, and that was the first time I've had any social interaction with you about the late Byrne QC. A lot of people may not, at the current bar, if you like, I mean, the new generation of barristers may not be familiar with him, but it sounds as if to me he had a massive effect on you as a lawyer, particularly with your practice. Stephen Norris described him in 2009 as the most outstanding criminal lawyer of his generation. What did you like about him, and what did you learn that has sort of carried through your practice as a barrister and maybe even into it as being a judge?
Well, to stay calm under pressure, to never stop working and researching for your client, to be courteous to your opponent at all times, to be respectful to the bench without never backing down from the bench. And what I really loved about Paul was that, well, there were so many things I loved about him, but as on a professional level, was that he could stand up and do a great plea in the local court, and he could stand up and do a high court hearing in front of 7 judges in Canberra, and he was equally, or a trial in front of a jury, and he was equally comfortable in every one of those settings. And it's one of the things I really aimed for, to balance between first instance practice and appellate practice. And I think it's incredibly helpful at both ends of that. Like, if you're good at the appeals, the judges in the Downing Centre treat you better. And if you've done a trial, the judges on appeal think, well, he actually knows what he's talking about.
Yeah.
That was one of the things about him. He also knew how to break out and have fun and go on holidays.
He had quite a variety of, he was very interested in cars, wasn't he? Racing cars and things like that. He had all sorts of models of them. But he had a great way of sort of putting things into perspective for you. There's a couple of great anecdotes where I think you were a co-defendant. You were for a co-defendant in a case, and you were about to cross-examine an expert, and you were a little bit nervous about it, and he leaned over and at the bar table and said to you, well, no, but, and the expert walked in wearing a bow tie, and he said, no jury is going to believe an expert that wears a bow tie. You know, I mean, no offence to anybody who likes wearing bow ties, including experts, but I just think it was just, he had a sort of pithy way of saying things too.
And it was just a way of reducing my stress level.
Yeah.
In a beautiful, funny sort of a way. He also said to me mid-rant, one day when I was very stressed about something and carrying on in his room, he just said to me, and he said it to me again on more than one occasion, they're all good cases.
Yeah.
And I actually spoke about him. Do you do links on your podcast?
Yeah, we can embed
can.
one. I know David, our production manager, will find a way to do it, so we'll embed a link.
That was the subtitle for that speech.
It was. They're all good cases.
Yeah, I like that.
And I really did cling to that because, you know, it was so true. It was like, this is such a great job that we do.
Sorry, just for the benefit of everyone, because I've started myself thinking about that in terms of when I'm getting a bit, you know, even lately of being nervous about a case and just thinking about, can you just discuss the content of that just briefly? Because I think it's got a beautiful resonance, I think, that statement.
I probably articulated it better when I prepared it, but like, they're all good cases. 1, this is incredibly important to somebody. 2, who gets to do this? Who gets to stand up in the High Court and talk to 5 judges? Who gets to represent someone who needs their help? It's a pretty good income. It's interesting every day. There's something in every case that's going to be important to someone or interesting to you. I don't know, it just had so many aspects to it.
It's a bit like one of those sort of koans, isn't it? KON, the things a Buddhist monk might say. And at the time you think, what does that, and it resonates. You think about it more as time goes by. And that's I've kind of
exactly what happened. I sort of walked out thinking, what on earth are you talking about? But it's never left me.
It's interesting to hear you say that, because it's the flip side of the stress coin, isn't it? The satisfaction the stress that you get from the work you do has the inverse effect on the satisfaction you get. And we've been looking at papers and studying this over the course of the year about how they work together and the excessive stress you mentioned earlier, if I can ask you about that. What was that relief you felt, when you were like, well, if I go to the bench, I can rid myself of some sort of performance stress. Well, can you just explain what you mean by that?
So I think I didn't, it wasn't that I had that prospective thought when I took the job. I guess I thought I could burn out in doing what I was doing. It never got easier. Like it didn't, you think it gets easier, but the cases just get harder. The expectation on you becomes higher as you get more senior. So even though you think, and look, in some respects it did get easier. I got more comfortable standing up in the Court of Criminal Appeal, which I found very difficult at first. Never got comfortable in trials. And I think it was more the day after I had the swearing in and then was in court the next day and I walked onto the bench, something was missing. And what was missing was that I had not slept properly and felt sick. It was more, I probably prospectively knew it, but it was more what happened immediately after I started.
What was the stress of the trials? What about the trial process?
So it's what makes trials great.
Yeah.
And that is the unpredictability of them. It is, you don't know what's going to happen. When you do that, someone's just walked into the back of the courtroom and you're wondering who it is. You don't know what the witness is going to say when they ask you the question. You can have, 5 exercise books full of notes for your cross-examination and all of them will become irrelevant after the second answer. You don't know whether the jury's just going to roll their eyes when you make that submission you thought was brilliant last night in the shower. You have no idea what the judge is going to do.
My shower advocacy is one of the best in the country.
You write all your submissions in the shower, don't you?
So the unpredictability is what makes trials wonderful.
But geez, my heart's just beating thinking about those things because I can relate to it, obviously.
But it's also what makes them so stressful. And it's all it's all happening then and there, and someone's going to win and someone's going to lose and someone's going to read the transcript.
And you said Paul Byrne said never stop researching.
Never
stop.
No.
You could, your preparation for a trial could be it's how long's a piece of string. I don't think there's ever a day where you can say I've done everything I possibly could. You within human limits, of course, but there's so much you can probably go back to work.
Well, my partner recently said she wasn't ready to start a trial, and I said I think I did 150 of them, and I wasn't ready to start any one of them. In my mind.
In your mind, I get that.
Exactly. It's a piece of string, isn't it? You were a founding member of Forbes Chambers when you were at the bar, and you said that you couldn't imagine then there being existing a more committed and rigorous group of criminal lawyers anywhere. How did you describe the culture there on that floor and some of the people, and did you find that inspiring?
So, I was a baby when I started there. I'd gone to Frederick Jordan Chambers when I left Mary Gaudron. That's why I went to the bar. Mary said, essentially, I had to. I could go and be a solicitor and do this and do that, but really just go to the bar. So I did. And I went into Frederick Jordan where Greg James and Ken Haller were, and they looked after me in those early days. And then the Council's Chambers Limited were buying the building, and there was a lot of fuss around it at the time, but the upshot of it was that most of the criminal lawyers decided to move out of the building and set up Forbes Chambers, and I think there were 30, and I think there were some people who were right in the middle of that, and then the people like me, and I think I got the very last room. And so there were, obviously, people very, very senior, Malcolm Ramage, Peter Boda, John Corn, Liz Fullerton. She wouldn't have been very senior then, but she certainly became that soon afterwards. Greg James, and then there were people like me, and then just above me, there in seniority were people like Philip Bolton, Ian McClintock, Graham Turnbull came on a bit later. Just fantastic people, and not really any competition between us. We were all pulling for each other, doing cases.
Lots of judges there. That's become a bit of a factory for judges, particularly in the common law jurisdiction.
This is a complicated question, but when did you realise that you were good at the job?
Good at being a barrister?
Yeah.
Look, I don't know. I could say something, purporting to be humble. I think I probably knew pretty early on that I wasn't bad at it. I was still terrified that I was going to mess up every single case. But I think,
is that what makes you good?
I reckon it is. I reckon it is. I didn't mention in the list of senior people Tim Gain and David Buchanan, who came on board a little bit later. But I had lunch with Tim recently. He must be one of the best barristers in Australia, with one of the strongest reputations, and yet he still thinks he's going to mess up everything he does, and the result of that is he works really, really hard. So, like, on one hand, I think I knew pretty early on I wasn't bad at it, and had okay instincts in a trial court. I knew I was smart enough because Mary Gaudron kind of encouraged me to believe that. But she also, this is one of the greatest jurists in Australian history. She, had, what's the word I'm looking for? Kind of imposter syndrome her whole life.
And isn't that the beauty of it, right? Like, so you think you're good, you realise you're good, you need to know you're good, but you need to be terrified that you'll be shit.
But you need to be insecure.
And then, God forbid, you have the day when someone tells you that you're not good. And then what do?
Usually your
right.
opponent.
Or the judge, or the outcome, or a vast array of things. Yeah.
You became, during your practice, quite a favoured or a favourite of the Western Aboriginal legal service. You practiced a lot in those courts. What did you learn about people, the law, that time? How do you reflect on that time of your practice as a barrister at all?
I mean, that was the most important thing that happened to me. I mean, if you put, Mary Gaudron as like one thing, lucking out and getting that 30th room at Forbes Chambers. And then Eric Wilson, who became a public defender, was then the principal solicitor of what was called the WALS, Western Aboriginal Legal Service, which was then a separate organisation to the ALS, based out of Dubbo. They couldn't get people to go, and they just wanted a baby barrister to go and do lists in Dubbo and Burke, and that led to doing trials. My first trial was in Cobar, with Brian Hancock, who also became a public defender. That was the most important, I would say above the other two things, really, the most important thing that happened.
It blooded you, I guess, but also aligned with probably your worldview or what you decided at least some point, what you were wanted to achieve, other than be a good barrister and a good living.
It was perfect for me. And it was, I went to the bar without that much, with very little advocacy experience. And all of a sudden I was doing a 90 matter list in Burke in front of a magistrate who hated me just for being there. And a prosecutor was probably having drinks at the pub with him. It was outrageous.
You were just felt an outsider, and you were really interloper even.
But you knew, because I wasn't defending myself, I was defending the bloke sitting behind me. And so you just fought for people because you had to. Like, it wasn't a matter of pride or dignity.
Well, you must be proud. You must be proud that that basically you've started a legacy. Not you started a legacy, but the legacy of being at ALS and being out in the West has become such a pioneering foundation for so many of today's top advocates. We interviewed Zoe Alderton earlier.
I reckon 80% of the new recruits on our floor have come through that path. Because we're a hybrid sort of, we're a common law floor, but there's a lot of people who do crime and want to do a bit of civil, but they mostly come in as having a criminal law background.
Well, you've got Toshi, haven't you? You've got Rebecca, she's marvellous.
Yeah, absolutely. Yeah. How could we dispute that?
Rebecca briefed me in my first trial out there.
That's right, at Burke, I think.
At Burke. And I've spoken about my illustrious trial experience on this show a few times, but I think she was.
Is it just to
How
remind
did
you?
that go, by the
No,
way?
just to remind everyone. Is it that you've never had a win in a jury trial? Have you had one?
I won some counts on the indictment, but they were probably they were inconsequential.
So technically speaking, you haven't had a win.
Well,
Or maybe
in life, how do you judge win these days? But I think Rebecca was most concerned not about my woeful experience in running jury trials, but the fact that I didn't know how to get to Burke. She was like, "What do you mean?" Like, I was like, "Is there a flight there?"
When we interviewed Stephen Walmsley, he didn't know where Yass was. Well, he was calling it Yass. And maybe that's a pronunciation. I think that's just his inflection. But he hails from Yes. Yeah.
Right.
So originally we were asking him about what he liked about the lamb
I thought you were
cutlets there.
saying that Stephen didn't know where it was.
No, sorry.
judging camera.
No. This my friend of us.
My
here.
parents came in the 70s from, mind you, my parents came in the 70s from Lahore to Lightning Ridge, and they spent. My dad was the country town doctor in Lightning Ridge and Walgett, but then they had me in '84 in Wollongong, and then put me to Balcombe Hills, and I haven't seen anything since.
All right. So the one thing about your practice at the bar, and I suppose that you said you found. Well, I thought was very interesting. You've said that you found the losses shocking, but of course, I mean the consequences, etc. But the wins, you said it took longer and more difficult to recover from emotionally.
Can I read that? Because I have a copy, a very privately kept copy, of a paper that formed the basis of a speech that you gave to the public defenders that I think
in
2020 that anyone who you speak to sort of speaks of that address as being so significant to them, because not only do you expose yourself in sort of the stresses of your own career, both at the bench and both as the bar at the bench, but also just really giving real life examples and advice. Now, without going into a lot of the detail, what stuck out for me, and it's what I kept tabbed, was when you said, a funny phenomenon I picked up over the years of practicing on the defence side was that winning cases had a more severe and negative impact on me than losing them, especially in cases that went on for a while. When I lost, I had a strong immediate emotional reaction. I couldn't work out why the jury hated me, why the judge was so unfair, why the prosecutor was a cheat, why I was so hopeless. This is harking back to our comments about our own fear. But that I could easily relate to. Then I went on to, but when I won, after the immediate adrenaline charge euphoria, I often slid into a kind of depression that would last for days. I never put my finger on why, but I think it had to do with living my client's life for the duration of the case, not focusing on myself or my problems at all, and then suddenly being confronted with my own personal demons and problems after the transient glow of victory. I just found that remarkable, because I think when I read it the first time and the second time, it just felt, we put ourselves into these cases, Nick, don't we? And we give it our all. Our family suffers. My kids don't get to see me before work. I'm eating unhealthily. I win the case. I've helped someone.
You've got a backlog of things you've been putting off, and then, whatever they are.
And all of a sudden, and then I've just got to face my life, and I'm just empty. I have days and days of emptiness that I can only, and this is, interview's not about me, but let me keep going, but I can only fix it by doing the next thing you said. While we all from time to time talk to ourselves about something known as the work-life balance and how we're going to take on less work and take care of ourselves, the reality is that the intensity of the work and its importance is such that we rarely actually do anything to relieve the pressure. We run on adrenaline. We bury ourselves in the work to avoid problems in our personal lives. We isolate ourselves. We mask our pain with alcohol or anything else, and we avoid showing weakness or talking to our friends and colleagues about our feelings. And I just thought to myself, sometimes I get lost in, well, I'm empty, I better just bury myself in the next work so I can feel again. And can you That's my personal life. But tell us about your story.
I mean, I think you've sort of put it quite eloquently. I think
you have.
Well, no. But
I mean,
what have I said after he read what I'd written? I think actually had showed. I just feel that's exactly it. That you for the length of the case, you are almost solely focused on that case and protecting someone else, and all of your own things go away, so you don't have to worry about the mortgage, or you don't have to worry about how the kid's going at school, or you don't have to, worry about anything except that. That's your singular focus. I've heard great, football coaches, sporting coaches say that the losses are devastating and the wins are just relief. Yeah. It's not elation. There is elation after a trial when a jury comes back and says guilty or not guilty, depending on whose side you're appearing on.
I wouldn't know what that feels like, but go on. Yeah.
Trust me.
Yeah, trust me. It's good.
It can be. It's just because, but part of that
it's overrated apparently.
Part of that is just the you don't know what's going to happen, surprise. But it's such a transient feeling, and then all of a sudden it's shit. What next? And your instinct is to find the next case to worry about, rather than maybe going and find out how the kids are going at school, or maybe And the other instinct is to go and get drunk. Yeah. And the real solution I ultimately found was to try to do nice things, go to beaches, get some exercise.
I've been trying to temper that range in a trial now, so that I can be a bit more present with my family in the evenings, despite my brain turning and churning. And but the moment my head hits the pillow, it's kind of like it's just boom. And His Honour James Alsop talked about it last time. About that performance stress, and how it sits through a lot of what we do. And
it's a big thing for even someone like James Alsop, who was, similarly a great barrister.
Who you read
himself.
with?
I did.
You did, yeah.
Okay, so part of the theory about let's abandon the stress, let's take a judicial appointment. Is that an illusory concept? Because it sounds like there's lots to be said for judicial stress.
Look, it's a little bit illusory. I think there's a bit of a distinction between pressure and stress. And I think I do not pretend that judges have the same stress as barristers and solicitors have. I think it's a different kind of pressure, and it's one that builds, but it is not that immediate feeling of being sick. I mean, I don't think I've had that since I became a judge. Like, there are times if I'm going on to sum up to a jury, I start taking deep breaths to get myself in the moment. If I'm going on to deliver a sentence and it's me exposed, there's a tiny bit of that, but it genuinely is tiny by comparison to addressing a jury or cross-examining the victim of crime, or the same applies to the prosecutor's role in eliciting evidence from the victim of crime or a complainant. I just do not think the stress levels are the same, but certainly the build-up of pressure over time, and the decision-making is obviously a different kind of thing, but it's not that immediate adrenaline rush of stress and anxiety. When I walk on to sum up, when I walk on to deliver a sentence, I've prepared it. Now, I may have prepared it hurriedly, and I may not be quite happy with it. I probably never am, but it's prepared in a way that, and your address to a jury is too, but you don't know how the jury's going to react, and you don't know where you're really going to go.
But you're not forced to contend with the unpredictability as nearly as much as you do if you're sitting at the bar table.
I mean, you sort of do in a trial. Like, things will happen where something happens with a juror or a witness plays up, and you're never expecting that. But you can usually just stop everything and take time. I mean, in that instance of going on to sum up, if I'm not ready, if I'm genuinely not ready. then I can delay that. I mean, one of the reasons I think I used to, when I had cases at Parramatta, I used to get there at about 7:15 for a 10 o'clock start when I was a barrister. And what I realised the day after I started as a judge is I can walk onto the bench when I like. Now, I'm not so discourteous that I just walk on when I like, but the reality is if I'm not ready to go on at 10, I can delay it. But the barristers are running to get there to make sure they're there
And
on
the smile will
time.
only be bigger if you're on the bench at 10:10 than at 10 o'clock.
And the potential consequence of an error too. I mean, obviously, if you make an error in your summing up or your directions to the jury, that becomes an appeal point. But ultimately, the consequences of someone of guilty v not guilty, if you feel, if that's at the heart of it as a barrister, criminal barrister, for example,
All the stakes
it's not there when you're a judge because you're less influence in jury trial and the outcome.
Yeah, no, I mean, I still get the sort of slight adrenaline rush when a jury comes back just because it is the most exciting theatrical moment that the law has to offer, except maybe 7 High Court judges walking onto the bench in Canberra. But I'm not invested in the outcome. And like if I make a mistake in the summing up, it's an enormous relief to know there's an appeal court that can correct it.
What's the judicial brain like when it comes to?
This is a big
Are you just going to put a question mark there, or are you going to go?
I mean, I am a law nerd, and is this why you brought this?
I just couldn't resist them. I've never heard of them before, and I thought of you two as soon as I saw them.
Yeah, well, I think the way I see this show is he's the nerd, he's the law nerd. I'm interested in people. Yeah. He's much more interested in the law.
Don't put me in a box, Nick.
He's in heart. He's a misanthrope.
I don't know you as well, Nick, and I just gave you the benefit.
No, I'm happy to be called a nerd because that comes flattery. It's a flattering thing from you, Judge.
What's the judicial brain like in a jury trial? Like you'll be sitting on murders. I mean, you spent should know this, but 15, 20 years as a jury advocate, persuading that jury about what you see. What's the judicial brain like when you're? I mean, are you still in part of you thinking like an advocate or where this should go, or is the judicial mind, where's the evidence on this, where should it land, where will it land, or are you detached from that process?
I reckon I'm detached from it, and I think I was detached from the start and relieved to be detached. Yeah. Like there's a bit at the end where in the way that I structure my summings up where I sometimes describe myself in anticipation of the jury as seeming a little schizophrenic because I'm about to argue both sides. Sure. When I put the prosecution's case and the defence case, and I sort of try to do it a bit better than the barristers do. I doubt I ever do, but I try, and I do it, in 5 minutes or less. What's taken them, and that's where I get to put a little bit of argument, but I really don't. Become involved or try to persuade think, this guy should be convicted, therefore I'm going to focus on the prosecution case.
That word detaches thing is really what I was trying to get at. Like, can you get there quickly? And the fact that you're there day one is fantastic.
That's what I felt. I never, for the first trial, and you have to provide a fair trial to both sides. That's the job. If you're not prepared to do the job like that, then don't take the job and don't get the pension and don't,
Have I taken you off?
Not at all. No.
Where are we on
we're
the
bouncing
roadmap?
around, and it's great. This is I'm very much enjoying. When you were a barrister, I'm sorry I keep going back to that, but it's just very interesting to me to compare the two, and I think it's interesting for a lot of people because it's a strange world in which you become when you're one and then suddenly you're the other, and I think people, whether a legal or non-legal audience, I certainly find that interesting. But you would you like reading, you're widely and well read. It sounds. And I don't mean that in a pretentious way. Obviously,
I don't read much anymore.
Well, yeah, but
I read Twitter.
It's not called that anymore.
Blue
is
Sky. I've moved.
Yeah, well, I think it's
Do you have
some
a Twitter
people
handle? Is it?
Yeah.
Not as far as you know.
Yeah, we'll leave that one.
Just trolling people.
You did a trial. It was an inquest into the death of a young man, Roberto Curti, who was tasered by police. We don't obviously need to traverse that in terms of factually, but it was interesting how you used the Joseph Heller quote, and it actually, in the inquest decision, it's the first thing that you see is quite a lengthy quote from. So it obviously had resonated with the coroner.
Yeah.
Was that something are you happy to recount the quote and how you used it incidentally in that case?
Yeah.
Is that something you're comfortable?
Roberto or Beto, whose family I represented in the inquest, had been tasered by a number of police, and I think also restrained in such a way that was probably at least partially responsible for his death. I should say very quickly, no police officer was convicted of any criminal charges arising out of the very few prosecutions that followed, but from the family's point of view, it was a significant crime.
You appeared for the family.
I appeared for the family and remains friends with the family, who are Brazilian. And so it was a quote from Heller.
Catch-22?
From Catch-22, where someone said, "Help, police." And it was ambiguous as to whether they were saying, "Help, save me from the police," or "Can the police help me?"
It was "help police," and help, and then exactly, and there was that sort of ambiguity keyed into what ultimately, obviously, somewhat was found in the. So it was quite effective, I thought, in the way that you did that. Did you find that doing things like that, giving that sort of some colour, and in your work as a barrister, that was something that was part of your advocacy style? You like to just sort of jazz it up every now and then, or use something like that.
Yeah, I mean, you couldn't
as a tool.
You couldn't do that very often. I was pretty comfortable in that court.
Yes.
And we were one little legal team in the face of, I don't know, half a dozen legal teams representing individual police officers and the Commissioner of Police, and then counsel assisting.
Right.
My instructing solicitor at the time, we had a roundtable meeting with all of the lawyers, and he walked out and said, "This is like impossible. We're just so outnumbered." And I said, "Don't worry, we're on the side of the angels."
Yeah.
He reminds Sebastian de Brennan, I don't know if you know him now, of counsel, but he reminds me of that from time to time. We're on the side of the angels.
Yeah, well, and I think solicitors love to hear that level of confidence from the
that flourish, well. that personality is something that has been a feature of your advocacy. How do you achieve that delicate balance of trying to be witty, clever, but also staying within the judicial
and not annoying to judges and things? Apparently, it's not always welcome.
No. I mean, I don't think being funny in court is something that should be reserved to the judge, as I think you both know.
Sure.
No. It's look. I never tried to be funny in court. That quote from Heller was absolutely not funny.
Quite serious.
I mean,
very,
not necessarily
very
funny, but like
quirky, maybe.
Quirky, but being like a personality, not always prefacing your submissions with, "in my respectful submission," just being a little bit unique. And, one kind of needs to look at your catchwords that are well spoken about, and we won't descend too much. But the state of New South Wales versus Reginald Collingwood, a pseudonym, 2021. Catchwords of the kind are misguided, paranoid, misogynist, -stupid things on Facebook. Manosphere, extreme right-wing philosophy, -personal grievances, -fraught relationship with Walgett Police, -capacity to manufacture explosive, -fanciful and grandiose. Do you get a sense of what this case is about?
Yeah, well, I certainly want to read it.
Now, these catchwords, I remember when I was a tippy to George Palmer, he'd let me do the catchwords. And I was they were pretty vanilla.
Is that what happened with you? Do your tip staff have any involvement in that, or you don't want to? You may not want to say. But...
Oh no. Well, we were very amused because someone had posted somewhere, "Wow, I can't believe Hamil J let his tippy get away with those catchwords."
Yeah, I think I might have read that on Reddit.
I do the catchwords. Look, it's a fine balance. I do it for some serious reasons. One is I think it's easier to find the case. If you want to find my judgment on judge-alone trials and when you should order one, look up. If you look up judge-alone trial, you'll get about 100 hits. If you look up lonely judge sitting in chambers, you'll get my case. If you remember, sometimes you remember those things.
You had a 5-year judge anniversary.
Yes.
That I weaseled my way into attending. Justice McCullum prepared you a cake.
Yes.
And the cake on it had all of your catchwords.
Well, that's almost
right?
true. What she'd done was in the style of Finnegan's Wake by James Joyce, a book I've never read, probably intend to ever read. She had woven in quotes from both my judgments and my case and my catchwords, and just done it in sort of that ridiculous, never-ending sentence
stream of consciousness style writing. Because there's a fair bit of that in Ulysses, isn't there?
Yeah.
That's a book you have read, though,
yes,
isn't it?
I've definitely...
How many times?
Look, I've read it once from beginning to end.
That's more than most
years
people.
And years, and now I just dip into it quite regularly.
And what about it is it that you need, that you take from it?
It's a celebration of every man.
That's it, yeah, because I wondered about that.
A Jewish man in Dublin who is, a loner in a sense, who's being cuckolded on the day in question. It's in his mind, it's in someone else's mind, the artist's mind.
I'm going to pick it up, that book, I think.
It's just, but ultimately it's a celebration of the common man.
Right.
And you can dip into it because there are just passages that give you things in and of themselves rather than from a narrative perspective.
And it's a celebration of life, and it finishes with the word yes.
Oh, okay.
And that's not an accident.
Yeah. Because some people probably think of it, an Irish, very heavy piece of literature that may not be as optimistic, because some of it isn't. I mean, Beckett, he wasn't that optimistic about life, and he's a contemporary of Joyce. So we did some reading of us. I just to return to this public defender's speech. I was quite affected by it when I read it. It really, obviously the anecdotal aspect of it was extremely moving.
I think I needed to postpone yesterday after reading it.
Yeah, seriously, it was. And so important for people who were working in the job to hear it from somebody at your level who seemingly probably they at least when you're a barrister and judge probably didn't know any of those things about how you were experiencing what you were doing. And it was really interesting to me that your conclusions, if you could call them that, or things that you wanted to, some insights that you wanted to offer, if it wasn't that didactic, but you kind of got there somewhere because obviously you're trying to help. We all need to be helped. It's to be part of what we need to do for each other in the business. There's a 50-page really interesting article which I think we provided to you before this, called. It was written by someone with the surnames, three of them, Shraver, Hubert, and Sorden. It's called "The Privilege and the Pressure: Judges and Magistrates' Reflections on the Sources and Impacts of Stress in Judicial Work." Right? It was from the Journal of Psychiatry, Psychology and Law, published this year. What I thought was really interesting was, so this is a study of it. They've spoken to lots of, I think mainly magistrates, and it explains probably one of the only central differences. You gave your paper from an anecdotal perspective largely. There's an incredible correlation between that. So I just think it's really important. What you were saying there is obviously the experience of broadly. So it's hard to summarise. There are lots of different statistical findings, but I think most interesting and probably accessible for the purpose of our discussion is that the top 5 things they found, based on the statistical analysis of the interviews, the empirical work they did, was workload was number 1 stressor, nature of case content, second, media and public scrutiny was one I thought interesting. I would like to return to inadequate resources and isolation. You'd obviously probably, would you agree with it in that order for you?
Look, I have to say, I know isolation is often referred to and there are lonely moments, but I am very lucky to work with extraordinary people, some of whom are very, very close friends, going back many years. And we have a great leadership at the court. And I mean, I don't want to give him too much of a rev up, but Andrew Bell and
Absolutely.
I don't feel that isolation. I also have made it a habit of remaining in touch with my friends at the bar, and I also have a wide variety of friends outside of the law. So yeah, I wouldn't list isolation necessarily, although I accept. And some judges are much more fastidious about not maintaining those contacts and feeling that it can compromise them. I mean, I have a thing going on at the moment where one of my closest friends, a public defender with a beautiful, beautiful young son, who they come and visit me every other weekend. And she's been part heard in front of me for 6 months. Former member of your chambers, in fact, Madeline Avenel, of senior counsel. And we bumped into each other. We got a night off for a mutual friend's wedding where we actually had a conversation with each other. But she would be a significant outlet for me when difficult times were happening. And I consider that I am for her. And we haven't seen each other for 6 months.
But you just can't, can you?
Well, that's right. You can't. Yeah. But the more general isolation, and that will happen, we'll always, a friend will appear in front of us and suddenly we can't see each other until we've made the decision. That is a factor. But as a general proposition, I'm just very lucky to have people around me that I love and who are there for me. And as I say, Andrew creates an incredibly collegiate atmosphere at the court, as did Tom Bathurst, I should say.
Just the subject of judicial stress, though, and the issues that Nick just mentioned, they have an impact on the profession and the bar specifically because they are in some ways the masters of the workplace, and that then can create a stressful situation. Stress can feed off stress. What's been your experience in the unmentionable topic of judicial bullying? I only say unmentionable because it was said to be unmentionable, but definitely now being given more attention to it. And in this paper I was speaking about earlier.
Yeah, well, I don't know that it's unmentionable because I noticed in preparing for today that I gave a talk on it in 2013 in what was no doubt a very important legal conference in Vietnam, and it's a problem, and people know it's a problem. It's becoming more understood. I spoke about it in that public defenders paper. I mean, that paper, whilst I was a judge speaking to barristers and solicitors, it was really more about the experience of the barristers and the solicitors than it was about the judges, although I thought the stresses were quite similar and mostly were the same. But there's no doubt that one of the major issues for the profession is how to deal with it. When you make a complaint, when it's bad enough, when it's actually crossed the line between a robust discussion and bullying. I mean, I said in that paper, I noticed as I quickly flicked through it, it was, I can't remember who it was, an American politician, that it's like pornography. You know it when you see it. And I think we all do. I mean, that paper was born out of a bad experience I had in the district court. And there's all sorts of problems with that. One of the problems is if the client gets a particular result, having watched the judge behave properly, they won't be devastated by the result. If they've watched the judge beat up on their barrister for a day and a half and then they get exactly the same result, they're going to be outraged by it because they're not going to feel like they had a fair go. That's one problem with it. Two is it's just incredibly psychologically damaging on the victim of it. I mean, you very gently introduced the subject of us by talking about the pressures on the judiciary, and that's causing it, and that's 100% right. But
it's just my innate deference to the to Your Honour. I mean,
very few people want to do it. Like, there's no judges get up in the morning and think, "Geez, I look forward to picking on whoever today."
Yeah.
But you might just feel that way, or the barrister might do something that triggers you, and then you react to it in a certain way that might be a little bit harsh.
Yeah, no, absolutely.
Even with only with the benefit of hindsight sometimes.
Nick's advocacy and your manoeuvring is just too gentle to ever get the cut.
You flatter me too much. I don't profess to.
My deep long pauses that you lament and my extended sentences get me in trouble at times, and you
like to talk,
and you leave it. Well, I've got things to say, Nick, and that's the point, really, is that you just want to be heard. And I've always said, whether I'm in the Small Claims Commission running my first ever case, or running any other appellate case I have, it's you want to lose with credibility. You want to lose having been heard. If you understand my argument, my job is done, and the rest is up to the judge. Now, getting to the point where you're allowed to present your argument, though, you can face challenges along the way from maybe a subconscious bias that's sitting in the way they're listening to you present the client, an interaction that's got you off guard, that then makes your advocacy so much more ineffective. The more you go along.
I think most people, you might be an exception to this of us, I'm guessing, but most people, most advocates do not get better when they're being picked on by a judge. Some do, some like the combat, and as long as everyone in the courtroom knows, I don't know if you remember Justice Rod Howie. Now, I reckon I got better when he started trying to bash me up. But it's because I knew it wasn't personal. I knew he just wanted to have a legal argument. He was
Socratic,
a nerd.
He's a nerd,
and he wanted to have the fight, and it could be the last day of term. In a case you could finish by 11:30 in the CCA, and you'd still be there answering his questions at 3:00 in the afternoon. No one wanted to go to lunch with him, I guess, but whatever. He just liked the fight. And it wasn't bullying. If you'd sat in the back of the court, you might have thought it was. But most barristers just get worse when they're attacked. I reckon of us, you might not be that person. I don't know. I'm not saying it's pleasant.
I think there are different times. I definitely enjoy the spar, and there's a pool of sweat, a puddle around me at the end of it.
Sure.
But I'm in there because I'm not going home. I'm not leaving that courtroom without having been respectfully understood. And you can disagree and all that, but there have been occasions, especially during the challenging periods where we were appearing by telephones or remotely in COVID, where you were in big lists with everyone on the telephone. And I remember having some experiences where I did get worse, and I think I talked about this in maybe an earlier episode, maybe I didn't, but I'm happy to share it. I even said I said to His Honour that I am having so much difficulty appearing before that I think my clients would really doubt my ability to persuade you of anything. I need to take their instructions if they want me to continue representing them.
Yeah, well, that's it. You happen upon another problem with judicial bullying, the confidence in the client.
Because the clients, you're going to come back and say, well, that didn't go well. Yeah, we saw that. Now, I've spent 4 days preparing for this and a day, can I still send my invoice? Then you lose the client, you lose the solicitor, and the ramifications then play into the shower advocacy that you do for the next week. So the performance pressure of
always
counsel.
best after the shower advocacy, all the things you think you should
because you
could have
could
said,
have
or
said.
questions you could have asked.
And that's when we talk about the performance stress of being a barrister, there are so many different things sitting on you, like the case you've got in 3 months, the outcome there, the reserve judgment that's waiting there. But then there's also that sort of, am I good enough point, which is why I go back to my other question, when did you realise you were good? Because you never know, because that judge just gave me an experience that said I'm not good.
There's also an affront to the dignity of the client themselves, or the litigant themselves, which I think every judge, and this is something we spoke about with James Alsop quite extensively, about the importance of judges, what everybody wants. And I think you've already touched on it. Everybody who comes before a court, a litigant, wants to be shown dignity. And if they get that dignity, the result will always be more acceptable. He and ultimately acceptable to them. He gave the example of a federal court judge called Paul Finn, or it's in one of his speeches, and it was apparently one of the litigants. It was in a migration case. He said, "This is a direct quote. It does not matter to me if I win or lose, as I sense the judge is a spiritual man who treated me with such respect that he will do what is right." Isn't it beautiful that that's his experience of that particular judge? And that's aspirational, I think, really is that you're attacking the barrister, but you're really attacking the person ultimately, because they're the one who's feeling it as acutely, and the rage and whatever they'll feel, and the resentment maybe towards their barrister or probably the judge too. So it's at so many levels, it's just critical, isn't it, that it doesn't happen. There's been there was a publication just a couple of days ago, some protocol for dealing with complaints of judicial conduct. It's a joint missive from the District Court, New South Wales District Court, and the Bar. They've set up a system with a judicial conduct liaison officer and an anonymous system of complaint. Because I think that's one of the issues is people will worry, well, what if I say something? So you can, if you're brave enough or it's egregious enough, stand up and say, yeah, you did it to me and I'm the one saying it, and it can be taken as far as it can be taken, but also can be made anonymous and put on a register such that if there's a pattern of it, because obviously sometimes judges are doing it as a reaction to something that's happened on that day and that moment, but if there's a pattern of it, I think that becomes very serious, doesn't it? And
I mean, look, I have a whole bunch of my former associates out there doing wonderful work, and I get, if they've had a rough day and they feel like they've been bullied, I'll get a call and I'll talk them through it.
Yeah.
And I'll often speak to Rebecca about the story, and her response will often be, "That's not bullying," which is interesting. I don't know if she's just tougher than most, but it is where there is that fine line, and people who are new at the bar or solicitors are finding it difficult. But there have also been instances where it unquestionably was bullying, and it was bullying of a baby solicitor first 6 months out. And I'm not going to talk about institutions or geographical locations, but the supervisors, got transcripts and were prepared to make a complaint. But my former associate was not prepared to let that happen because the concern was that it would make it worse, and that nothing would happen. And so I've not read that. I am aware of it, but there clearly has to be a way that people can make their complaint anonymously so that they're not in fear, which is just going to make the psychological impact worse, that they're going to be, brutalised for making the complaint.
The thing, isn't it?
And if it's not just...
I'm not sure if it... I mean, it has to be largely directed towards bullying. It might best be directed towards, general grievances. But
perhaps some of the best people... Going back to the distinction between, well, that's not bullying or it is bullying, I mean, people. It's about, I think we mentioned the impact on the victim, and some of us have a thinner. Think of the eggshell skull rule. Some of us have a greater susceptibility to being to feeling upset by an interaction than others. I wonder if
that's not their fault, is what you're
it's
saying.
not the judge's fault necessarily.
But it's not the person's fault. If that's how they feel, that's
If
what they feel.
it feels like bullying, it kind of is bullying.
Yeah.
Like if the victim feels that. Sorry.
But no, I agree with that. But maybe the support that is required is not just a complaint setting, but also it sounds like people best placed to help you with these things are barristers, are senior barristers, are people who have been through it and can sort of evaluate it with you,
or even judges. The people. So you say people can ring you up and do colleagues.
Yeah,
and
special people.
Special people.
Well, they're all my former employees or friends or whatever.
Yeah. We weren't suggesting there was going to be a hotline you opening up.
My mobile number.
That's what I'm suggesting, that we should maybe think about.
I think having the interactions between the profession, I mean, this is particularly true in regional courts. You know, in the old days when I was a petty sessions officer, there'd be morning tea every day where the magistrate and the solicitors would be having that. It's a whole lot harder to go in and bully someone when you've just had a coffee with them, I think.
It's funny, I had an appearance recently before a judge who, I won't even give you a division, I was running a very complex, to my mind, argument that was just being rinsed. And I was just trying to get understood. It's like, you're just not understanding me, we can do this. And it was just felt horrible. And I
understand you.
Thank you. So many emotions this morning. And I just wanted to sit outside and just seethe during the morning tea adjournment. Anyway, and he invited us in for morning tea. And he sat there with my opponent and they were just chatting and I was just there smiling, having my tea, seething in company.
I used to think it was a bit quaint and a little bit like the good morning thing, which is obviously frowned upon. But I had the exact experience with a judge in a court somewhere, who I'd already had something in front of that judge a few months before and got severely bullied. It was a sort of and I was a baby barrister. It was the sort of, what are you doing here? And how dare you even want to be putting that argument? There's just no way you could possibly win. And the argument was, we'd lost, but it was one of those interlocutories where you can run it again at the final hearing. And the argument, the other barrister, because I got taken off the case as a result. Yeah. Well, I didn't. I just certainly, I don't know, it was as a result, but it seemed to me that way. That argument was made good at trial, and it was a limitation argument, which are always unattractive, but sometimes you've got to make them. Was made good, and that decided the case. But the case went on and cost everyone a lot more. But I'm not bitter about it at all. But I then had a trial, a full trial in front of this same judge a few months later, and I was very, very nervous about it. I remember with my wife speaking about it the evening before, and being, all those physical feelings, and the judge at morning tea was an old school judge and was a coming into our chambers. So in my chambers, and I was very nervous. We'd started up, we'd had a little bit of, and we went to morning tea, and we sat down, and it took me a while, but I thought, I'm going to get into this discussion, and I could tell the judge was into cricket or whatever. We were talking about something neutral, and we had a very nice discussion, and it changed everything. The trial, it was so much more pleasant. It was a 3-day trial. From the rest of it, there was exchange. There was some robust exchange. It was just such a better experience. And this is the thing where traditionally there's been, and particularly even more so probably now, there's this division, that all that stuff's gone away, where we're here, you're there. But
and the
I
lesson,
think there's room, as you say, for a bit more.
The lesson, Nick, for our common lawyers out there, never run a limitation defence on an interlocutory basis, except in the most clearest of cases.
Thank you of us for your law nerdery. Do we need? I'm a bit torn. I'm a bit torn because I don't know whether to frame them, and as something of our show that we were given a box of nerds by His Honour Justice Hamil, or to open them now and for us to all have one?
I'm not sure about that.
How do
Are
you?
we still going to be speaking? I don't know what a nerd is. I mean, apart from
Well,
the
it
legal
described
sense.
tangy and crunchy and sweet and gummy inside.
Sounds outlandishly delicious.
Doesn't it?
Did
really?
you
I
not
mean,
have nerds when you were a kid?
it sounds a
They
bit
were-
like
I had never
it-
heard of
it
them
sounds
until
a
I
bit-
saw them today.
So nerds were these
It sounds a
lollies
bit
that
like you,
Yeah,
doesn't it? Again, even the
tangy,
flavors and
crunchy,
stuff.
and a little bit gummy, a little
Yeah.
bit soft in your centers.
No, I did. Oh,
Anyway,
yeah.
no, it's just always susceptible. But when we were a kid, we used to have like these. They're very tangy, beautiful purple and green, sugary things. They're very lovely. I think we're gonna.
No,
I want to hold on to
I
them.
want to preserve them. It's actually, yeah, no, I know it sounds a bit sentimental, but no one's given us anything. We probably should be doing the giving on the
Should
show.
we? I wonder if
Can I
we've. I just wonder if David's time.
I have one more question. I just need to revisit the Yankees dream. So when you were at the time you were sworn in as a judge of the Supreme Court, you said you had a dream where Yankees, obviously, as we've said, sworn enemies of the Red Sox. You had this dream where an old lady came up and, as you were getting fitted for your robes, whispered in your ear, "Go Yankees, go Yankees." I maybe might have said it a bit like that. Maybe that's my poor impersonation. Have you had it again, or has it ever? Has anything to do with that revisited you?
No, in fact, I'd not. When you said it, I thought, what dream? And then, of course, I remembered that I mentioned that. Did I not in the speech?
Yes, you did.
It was all about. It was all a part of the theme of what am I doing with my life? How did I get here? And that seemed me subconsciously saying that I was, because you would know and understand that the Yankees are like known as the evil empire. They have all of the money. They always win. Yeah. And we battle.
Unlike Collingwood, we won't.
We don't have to.
Different. Yeah.
Collingwood's working class. Irish
They
too,
are
by the
indeed,
way.
actually, right.
But so it was just my subconscious telling me, what's the word where you go from being the poacher to the something? I don't know.
The hunter.
That I was
the
joining
poacher.
the establishment.
Yes.
That was what that. I reckon that was what. That,
That's your read into it.
I thought it was
your
pretty clear cut.
Your first establishment.
Go Yankees.
Can I?
Vasa's got one more.
No,
because
it's not necessarily one more, but it's just, I think, an area that we can't miss, which is sentencing. And I specifically wanted to come back to a more serious point for a moment. When you were sworn in, you made an effort to quote various judges in how they've approached the sentencing process. Now, we've discussed this on the show a few times. The individualisation of justice being paramountly important, but also having faith to the Sentencing Act. You quoted Justice Hunt, who, in sentencing a man called Muir, who had shot a friend, who said this: "The prisoner has no relevant previous convictions. He is in effect at a turning point in his life, and in my view, the community, if fairly apprised of all of the facts, would accept that the prisoner should be given the chance to work his way through to a better future, rather than that he should be flung onto the human scrap heap of society by an uncaring criminal justice system, simply as a warning and an example to others." He went on to say that I've no doubt that I will be criticised by those that have set themselves up as professional critics of the court, either in deliberate ignorance of the facts or deliberate disregard of those facts, seemingly intent to destroy any chance for rehabilitation of offenders by demanding their incarceration in conditions which inevitably crush any hope for their future. Words in 1991, said by Your Honour in 2014. Quoted, but there was obviously a message in that. Can you elaborate it for me?
Well, I feel like the demonisation of criminal lawyers, defence lawyers, the ongoing call for higher and higher sentences was obviously around when Justice Hunt was writing in Muir. They might be extempore remarks, which is incredible as well. But I think it has continued, and I think there are studies that show that where a fair-minded member of the community knows the whole facts of the case, they often find the sentences to be either quite stern or at least fair. Whereas if they only know the bad thing that the person did, which is often the terrible thing, or is portrayed as that in the media, then they think the sentences are a joke and too lenient. And I think that one of the things that judges have to do is to strike that balance between, as the High Court put it in Munda, vindicating the dignity of the individual victim, but also balancing that against the often appalling subjective personal circumstances of the offender, to provide some hope for rehabilitation, because the community is better protected by rehabilitation when you can't generally lock someone up forever. So sentencing is really difficult, and it's probably the hardest thing we do. I often say to the district court judges who are friends of mine, we don't have it as hard. With most cases where I'm sentencing someone, it's just about how long. Like, you're not going to get a bond for murder. Whereas in the district court, judges are constantly confronted with what obviously Justice Hunt was confronted with there is, do I lock this person up knowing it won't do any good for anyone? Maybe it'll make the victim feel better for 5 minutes, but probably won't. Or do I take a risk that tomorrow I'm going to be on the front page of the Telegraph for being weakly merciful? And His Honour was always courageous and would have taken that punt. But it, bail's another very difficult part of our job, where you've really sometimes got to take a risk with someone because that might be the moment in their life where they rehabilitate. But,
these are all potential turning points in massive.
But the other side,
James said last week to us when we were interviewing him, he said, well, those that criticise don't have to do it. But
what I really have found interesting in is those studies that show that those members of the communities who would howl for higher sentencing when appraised, I think to use Justice Hunt's word, of all of the circumstances, would understand that compassion in sentencing at that moment is actually the right thing to do. And there are some cases where the person's incorrigible and the only way to protect the community is to lock them up for a very long time. But there's no black and white.
Well, Judge, it's been great. It really has. I mean, we're just so grateful for you to come on and share so many of these insights. It's just really has been fascinating and very enjoyable and quite meaningful and moving for us. Some of the things you said, because they really resonate. They've really resonated, and are very important things to be said. Albeit I don't think controversial in the sense that they're things that all of us are feeling and know. But it's amazing to have someone of your expertise and gravitas say what you've said today, and we're eternally grateful. Thank you so much.
Thanks, Nick.
for coming on the show.
It's been a pleasure.
So that's the end of our interview with His Honour Justice Hamill. Thank you so much for joining us, and we look forward to catching you the next time.
See you next time, guys.
Bye.
This concludes the first season of Elephant in the Courtroom. We trust you've enjoyed it as much as we have, and thank you for listening. Until next time.